The last, but definitely not the least characteristic of a penal law is the principle of prospectivity. What is this principle of prospectivity of a penal law? The prospectivity of a penal law simply means that a penal law can be enforced only from and after the time of its enactment, meaning from the time the law takes effect. It cannot be made applicable to acts or omissions before such penal law became effective. For example, under the Coconut Preservation Act, or RA 8048, it is illegal to cut a coconut tree without first securing a permit from the Philippine Coconut Authority. The law took effect on June 7, 1995. If X, let us say, cut several coconut trees on June 6, 1995 without a permit from the PCA, question, is X liable? The answer is no. Why? Because there is no crime when there is no law punishing the act or omission. RA 8048 being a penal law only has prospective application. It cannot be enforced with respect to acts or omissions committed prior to its enactment. What is then the basis of the principle of prospectivity? Take note that penal laws as a rule only have prospective application. This is so because Article 3, Section 22 of the 1987 Constitution prohibits the enactment of ex post facto laws. Ano ba itong ex post facto law? An ex post facto law is a penal law that is given retroactive application to the prejudice of an accused. Hence, a law is ex post facto if, number 1, it makes an act or omission as a crime when it was not so when committed. For example, a law enacted in 1989 penalizing the possession of an unlicensed firearm was made to apply to a person who possessed an unlicensed firearm in 1985. Number 2, a penal law is an ex post facto law if it imposes a penalty higher than when it was committed, or aggravates a crime or makes it greater than when it was committed. For example, a law is passed increasing the penalty of homicide from reclusión temporal to reclusión perpetua and made applicable to homicides committed prior to the enactment of the said law. Number 3, a penal law is an ex post facto law if it requires a lesser degree or a lesser quantum of evidence to prove the guilt of the accused than when it was committed, or it receives less or different testimony than the law required at the time of the commission of the offense in order to convict the accused. For example, a law is passed which only requires preponderance of evidence to prove the guilt of an accused and made applicable to acts or omissions committed prior to the enactment of the said law. Now, if I may add further, even if such a law is not given retroactive application, still it will be struck down as unconstitutional. Why? Because it will what? Violate the due process clause of the Constitution. Take note that an accused has in his favor the presumption of innocence, which the Bill of Rights guarantees. Unless his guilt is shown beyond reasonable doubt, then he must be acquitted. This reasonable doubt standard is demanded by the due process clause of the Constitution, which protects the accused from conviction except upon proof beyond reasonable doubt. Number 4, a penal law is an ex post facto law if it deprives an accused of some lawful protection to which he has become entitled, like for example, the right against double jeopardy or of the proclamation of amnesty. For example, a law is passed allowing the prosecutor to refile the same criminal case after the accused had been acquitted by the court on the merits. This clearly violates the constitutional right of the accused against double jeopardy. Another example, X, a rebel, was granted amnesty. A law was later enacted by Congress allowing the criminal prosecution of former rebels who were previously granted amnesty. This is again what? An ex post facto law because it deprives X of the benefits of the proclamation of amnesty to which he was granted. Number 5. A penal law is an ex post facto law if it alters, in relation to the offense or its consequences, the situation of a person to his disadvantage. For example, a law is passed disallowing probation for those convicted of crimes where the penalty imposed does not exceed 6 years imprisonment, and such law is made applicable to those convicted of such crimes and who have already availed of probation prior to its enactment. And number 6, a penal law is an ex post facto law if it assumes to regulate civil rights and remedies only, but in effect imposes a penalty or deprivation of a right which, when done, was lawful. For example, RA 1379 provided for the forfeiture in favor of the state any property found to have been unlawfully acquired by a public officer. The same law provides that it shall apply not only to property thereafter unlawfully acquired, but also to property unlawfully acquired before the effective date of the said law. Now, the Supreme Court, in declaring RA 1379 to be an ex post facto law insofar as its retroactive application is concerned, ruled that forfeiture partakes of the nature of a penalty, and that proceedings for forfeiture of property, although technically civil in form, are deemed penal in nature. Hence, it follows that the penalty of forfeiture prescribed by RA 1379 cannot be applied to acquisitions made prior to its passage because it will clearly violate the constitutional prohibition against ex post facto laws. This was the ruling in the case of Republic versus Katigbak. Take note, however, that the prohibition on the enactment of ex post facto laws applies only when the law is prejudicial to the accused. In other words, if the retroactive application of a penal law does not prejudice the accused, then it will not be considered an ex post facto law. Can a penal law, therefore, be made to apply to acts or omissions prior to its enactment? The answer is yes, as an exception to the prospectivity principle. This happens when a penal law is favorable to the offender, provided the offender is not a habitual delinquent. What is then the basis of the exception? The basis is found in Article 22 of the Revised Penal Code, which states, and I quote, "Penal laws shall have a retroactive effect insofar as they favor the persons guilty of a felony who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this code, although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same." A penal law, therefore, can have retroactive application if it is favorable to the accused or offender and such offender is not a habitual delinquent. Moreover, its retroactive application does not only apply to pending criminal cases, but even to criminal cases where a final judgment has been pronounced or to convicts already serving their sentences. Take note of that. Question: is it necessary that the penal law itself expressly provides for retroactivity? The answer is no. And also, the accused himself doesn't need to invoke its retroactivity. Courts are mandated to apply it irrespective of whether or not the accused has availed of the same. An instance where a penal law is given retroactive application because it is favorable to an offender is when it imposes a penalty lower than when the crime was committed. For example, RA 9346, a law prohibiting the imposition of the death penalty, was given retroactive application with respect to convicts who were sentenced to die by lethal injection prior to the passage of the said law. In lieu of the death penalty, the penalty of reclusion perpetua or life imprisonment, as the case may be, was imposed. By the way, who is a habitual delinquent? A person is a habitual delinquent if, within a period of 10 years from his release or last conviction of the crimes of falsification, robbery, estafa, theft, serious or less serious physical injuries, he is found guilty of any of the said crimes a third time or oftener. Thus, if an accused or convict is a habitual delinquent, he cannot avail of the retroactive application of a favorable penal law. For example, a law was passed lowering the penalty imposable for homicide from reclusion temporal to prisión mayor. Now, prior to the passage of the said law, X had been convicted by final judgment for homicide. If X is not a habitual delinquent, then he will be benefited by the retroactive application of the favorable penal law.